Vernonia v. Acton, 515 U.S. 646, 1995. Related court case. Elkins v. United States, 364 U.S. 206, 213, 1960. New Jersey v. TLO, 469 U.S. 325, 336-337, 1985. Skinner v. Railway Labor Executives Acton, 489 U.S. 602, 617, 1989. Board of Education v. Earls 536 U.S. 2002. Essential question. Can schools test students for drug use to participate in district-sponsored activities? Main participants. Vernonia School District 47J, James Acton and parents. The complaint. In 1989, Vernonia School District in Oregon had instituted a policy to test athletes for drugs. This was due to an increase in drugs among the student body, with some prominent student athletes leading the way. After agreeing that drugs had a direct relation to sports-related injuries, the school district passed the student-athlete drug policy. The policy applied to all students participating in interscholastic sports and required them to sign a consent to be randomly tested for drugs. In 1991, James Acton, a 7th grader, wanted to play middle school football. James was one of the brightest students in his grade. He had never been referred to the principal's office. The Acton family felt that should be proof enough that he could play football at his school. They did not sign the consent, and James was not allowed to play. The Acton family felt this infringed on their son's 4th and 14th Amendment rights. Legal precedent. The 4th Amendment to the United States, the right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures. The 14th Amendment covers the right of a person to the constitutional guarantee to searches and seizures by state officers. In Elkins v. United States, 1960, public school officials were included. In Skinner v. Railway Labor Executives, 1989, it was determined that state-compelled collection and testing of urine, like the testing completed in Vernonia through the student-athlete drug policy, constitutes a search subject to the demands of the 4th Amendment. Court rulings. The Actons filed suit claiming that the policy violated the 4th and 14th Amendments and the Oregon Constitution. The district court action was lost. Ninth Circuit Court of Appeals overturned the lower court, citing that the policy violated both federal and state constitutions. 1995 U.S. Supreme Court reversed the appeals court. Justice Scalia delivered the opinion of the court. Classroom impact. In today's society, this case has a huge impact on the classroom. More and more states are legalizing recreational drugs. However, it is still not acceptable within schools. Therefore, policies like those implemented in Vernonia are still in effect and will be upheld, with this case used as a precedent. This case proves that it is the responsibility of teachers, administrators, school boards, and parents to protect the safety of the students. Are there any questions for Brett Casey?